the first source will be only by way of promotion. That will be in consultation because under
That may be their argument.
that it is only by way of promotion. That is only their argument, and somehow it is not there anywhere in the article, but somehow it has come from somewhere. But in the case of appointments of persons to the judicial service, other than as district judges, they will be made by the governor of the state in accordance with the rules framed by him in consultation with the High Court and the Public Service Commission. But the High Court has control over all district courts and courts subordinate thereto, subject to certain prescribed limitations. So far, there is no dispute. But the real conflict rests on the question whether the governor can appoint as district judges persons from services other than the judicial service. That is to say, can he appoint a person who is in the police, excise, revenue, or such other service as a district judge? The acceptance of this position would take us back to the pre-independence days, and that too in the conditions prevailing in the princely states. In the princely states, one used to come across appointments to the judicial service from police and other departments. This would also cut across the well-knit scheme of the constitution and the principle underlying it, namely the judiciary shall be an independent service. Doubtless, if Article 233(1) stood alone, it may be argued that the governor may appoint any person as a district judge, whether legally qualified or not, if he belongs to any service under the state. But Article 233(1) is nothing more than a declaration of the general power of the governor in the matter of appointment of district judges. It does not lay down the qualifications of the candidates to be appointed or denote the sources from which the recruitment has to be made. But the sources of recruitment are indicated in clause 2 thereof. Under clause 2 of Article 233, two sources are given, namely 1, persons in the service of the union of the state, and 2, advocate or pleader. Now, this is not just pausing here for a moment. They are interpreting 233(2), that under 233(2), two sources are given. One is persons in the service and the other is advocate or pleader. And yet, Lord Dheeraj Moore says, ki no, 233(2) excludes those in service. Completely contrary to this. It does not lay down the qualification. But sources of recruitment are indicated, namely 1, persons in the service, and 2, advocate or pleader. Can it be said that in the context of Chapter 6 of Part 6 of the Constitution, the service of the union of the state means any service of the union or of the state, or does it mean the judicial service of the union or the state? The setting, that is the chapter dealing with subordinate courts in which the expression the service appears, indicates that the service mentioned therein is the service pertaining to courts. That apart, Article 236(b) defines the expression judicial service to mean a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. If this definition, instead of appearing in Article 236, is placed as a clause before Article 233(2), there cannot be any dispute that the service in Article 233(2) can only mean the judicial service. Namely, judicial service is included in Article 233(2). The circumstances that the definition of judicial service finds a place in the subsequent article does not necessarily lead to a contrary conclusion. The fact that in Article 233(2) the expression the service is used, whereas in Article 234 and 235 the expression judicial service is found, is not decisive of the question whether the expression the service in Article 233(2) must be something other than the judicial service. For the entire chapter is dealing with judicial service. The definition is exhaustive, etc. Then your Lordship will have just above placetum D, having defined judicial service in exclusive terms, having provided for appointments to that service, and having entrusted the control of the said service to the care of the High Court, the makers of the Constitution have not conferred a blanket power on the governor to appoint any person from any service as a district judge. Reliance is placed upon the decision of this court in Rameshwar Dayal in support of the contention that the service in Article 233(2) means any service under the state. The question in that case was whether a person whose name was in the roll of advocates of East Punjab High Court could be appointed as a district judge. In the course of the judgment, Justice S.K. Das, speaking for the court, observed, Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union of the state, no special qualifications are laid down. And under clause 1, the governor can appoint such a person as a district judge in consultation with the relevant High Court. As to a person not already in service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. This passage is nothing more than a summary of the relevant provisions. The question whether the service in Article 233(2),
as a matter of fact, they depart from the view taken in Rameshwar Dayal. Though
Well, to the extent, yeah, your lordship is right, because that's
Says that any service.
right. Because, my lord, they had cleared people who were not in the judicial service, namely those two.
That was the situation then.
Correct.
Similar now.
That is correct. Your lordship is absolutely right. As a matter of fact, they depart slightly to limit it to.
This is under the
Because
constitutional scheme.
they raise their foundation on the doctrine of
Yes.
separation of powers
Yes.
and independence of judiciary.
Correct.
Yes,
Correct. But one thing is clear from both the judgments, that 233(2) includes both these streams. Both the judgments say it. And as your lordship rightly asked, my lord, how did Dheeraj Moore come to the conclusion that no, it's an exclusion rather than an inclusion? Then, my lord,
Stream is something which is created by us, not under the constitution. The constitution really says promotion and then direct recruitment, that's all. The qualification is time, and obviously lawyers cannot be considered for promotion because they are not working as judicial officers. There is no exclusion of judicial officer under 232.
yes.
I mean, if it is recruitment is there, expressly.
Then, my lord, that fourth question, can people in the judicial service be excluded? Your lordship had seen questions 3 and 4 were relevant. So 3 they answer by saying that no, this has to be only the judicial service, not the executive service, not any other service. And 4 they leave open. They don't answer that at all. Can they be excluded? That your lordship will find, my lord, at page 195. The small 2-line paragraph between placetum C and D. In this view, it's not necessary to express our view on the last 2 questions. But naturally, the corollary of what they've held would be that you cannot exclude the judicial service. If there are 2 streams, one is the service, which means judicial service, and the other is advocates. But naturally, in fact, I'll come to that in a moment, my lord. And that is the next issue that I need to address before your lordship. So therefore, my lord, on the first point, can't see. वो जो हो रहा है करें
తాజాగా కేంద్ర ప్రభుత్వం జిఎస్టీ స్లాబ్ల తగ్గింపుతో కార్ల ధరలు భారీగా తగ్గాయి. దీంతో షోరూమ్ల
Now, Lord, so therefore, in my humble submission, I have finished with the point of whether 233(2) includes that second stream.
According to the 233, includes both the streams.
Yes,
మధ్యతరగతి
And the finding of Judicial Moore,
is
that
completely wrong.
233(2) is exclusively
Yes.
for the members of the bar,
Now, Lord,
is not correct.
correct.
In
Now,
other words, we'll try to understand the argument.
yes,
233, 1 and 2, they speak about, they don't distinguish between the promotion and other things. So therefore, qualification is in 233.
Lordship, yes.
And then 233, one it generally speaks about who is the authority to do it, whether it is promotion or a recruitment or appointment.
Correct.
These are all general.
Right.
Governor in consultation with
మధ్యతరగతి
this.
కుటుంబాలకు
And then second
కారు
thing,
కొనాలనేది
it only
ఒక
specifies the
కళ.
qualification
తాజాగా
of the
కేంద్ర
other
ప్రభుత్వం
lawyer.
జిఎస్టీ
Therefore,
స్లాబ్ల
read 1 and 2
కార్ల
together.
ధరలు
That does
భారీగా
not,
తగ్గాయి.
restrict
దీంతో
only to
షోరూమ్ల
judicial and
తాకిడి
therefore,
పెరిగింది.
does not
దసరా
restrict
ఫెస్టివల్
the
ఆఫర్స్ తో
lawyers.
పాటుగా ఇటు
Correct.
జిఎస్టీ
Both will have to
స్లాబులు
be
తగ్గడంతో
considered.
కార్లు కొనాలనుకునే వారు కూడా
exactly
కార్ల
how-
షోరూమ్లకు
how
వచ్చి
the
వారికి
two constitutional
నచ్చిన కార్లను
Lawyers
బుక్
cannot
చేసుకుంటున్న
get into,
పరిస్థితి కనిపిస్తుంది. మనం చూడొచ్చు.
Correct.
There's no bar for them to come under that.
Right.
Because there is no express exclusion.
Right. Now, my Lord, that leads me to the next question, which is, supposing the Constitution provides for these 2 sources, can by rules, can you exclude one source completely from direct recruitments? And that immediately raises, my Lord, the Article 14 question. Now, in this context, please note, my Lord, that all the judgments which have dismissed the Article 14 argument base it on their Lord, finding of 233(2) itself excludes those in judicial service in direct recruitment, and therefore you're not eligible. Therefore, there's no question of Article 14. None of them has gone to the extent of saying, no, no, there are two sources, but one can be completely excluded. So the Article 14 question is very, very not clear. If there are two sources provided for by the Constitution, according to me, my lord, one, you cannot just shut out one. Then you are doing something contrary to what Volume 5 to PDF 72. It's showing Shetty connection first. It's volume. So therefore, my lord, my submission on this is, if the
Which are, whether the rules framed by the state governments in consultation with the High Court provide for exclusive bar members.
yes, it does, my lord. Your lordship will have a look at volume 4. We have the UP rules. Just have a look at page 415, rule 5.
Page,
Volume 4, page 415. This is the UP rules, my lord.
UP Higher Judicial Service.
Yes. UP Higher Judicial Service Rules 1975. And if your lordship turns to page 415, rule 5, under part 3, recruitment.
Yes.
Sources of recruitment. The recruitment to the service shall be A, by promotion from amongst the civil judges, senior division, on the basis of principle of merit cum seniority and passing a suitability test. B, by promotion strictly on the basis of merit through limited competitive examination of civil judges senior division having not less than 5 years qualifying service, which your lordship has directed to reduce it to 3 years. And C, by direct recruitment from amongst the advocates who have been not less than 7 years practicing as an advocate on as on the last date fixed for the submission of application forms. So direct recruitment only from advocates. For civil judges, only promotion and this limited departmental comparative exam. You are excluded from direct recruitment.
Amounts to reservation.
I'm sorry, my lord.
Amounts to reservation.
Yes, amounts to reservation in favor of the advocates. So now the question is, can such a rule be, my lord, supposing your lordship holds that 233(2) does not exclude civil judges, persons already in the judicial service. In fact, it includes them. Can the rules exclude them completely? That direct recruitment will be only, my lord, of advocates. In my humble submission, no. That would be doing, my lord, violence to the language of the Constitution and the intention of the Constitution makers. The promotion or that limited direct departmental comparative examination is not a substitute, because that, as your lordship has noticed in that
In any
recent
case, both
judgment.
these constitutional bench judgments,
Yes,
they deal with the direct appointment.
yes, correct. They were not promotions. They are not saying, they were both dealing with.
Therefore, they did not say that you are not even qualified. See, if the question of qualification is there, there's no need to discuss that.
Right.
Yeah, that is the issue. The problem is
Your lordship
that,
is right, but
problem is that, you see, by the order of the
ultimately-
court, they
ultimately-
created two channels.
Ultimately,
And
my
we
lord,
try to understand the constitutional mandate through that, through those channels.
correct.
That's the
But-
problem.
Not two, three channels.
Three channels, yeah, three channels.
but
Yeah,
then, my lord,
at least.
somebody will have to strike down the rule. The rule is excluding us. Once your lordship holds that no, the constitution permits, then according to me, the answer is very clear. Then the rule is wrong, excluding us completely. Because till the rule is set aside, that rule still remains and still excludes us. Therefore, my lord, that was our prayer in the writ petition, namely set aside this rule which excludes us. That will ultimately have to be allowed. So I'm just very briefly addressing your lordship on that. Now, my lord, I want to show your lordship the Shetty Commission report. Same volume, volume 4.
Till we create the different modes of recruitment,
Yes,
as you rightly said, there's only one way.
yes,
Somebody to be appointed as a judicial judge. Supposing it comes by promotion, the others will not have any grievance. It can be regulated only under that. Now, earlier what was there that the district judge is separate appointment. So they said, who are all qualified to be appointed? There is only one mode. So which means, the judges also be eligible. And then those who are lawyers who complete the 5 years, they become eligible. That's only one matter of recruitment. To that extent, the other point of there was one issue. Once we created the subcategory, that's
correct.
said,
The
one through limited company examination, one channel, small channel.
your lordship is right.
Then it is the promotion. Then we are trying to understand the mandate of the Article 233 in the light of the factual scenario. That creates a lot of other issues.
Absolutely right, my lord. In fact, that's my case. That what they are saying, one of the arguments that they make is, look, under the rules, 75% of the posts are in any case reserved for civil judges, 50% by promotion, 25% by way of this limited departmental comparative exam, and only 25% are left for lawyers. Therefore, that must be upheld. But that's not putting the cart before the horse. Namely, you are saying that you must look at the rules to interpret the constitution. That can't be. And my lord, yesterday, for the first time, I found a direct judgment on that subordinate legislation cannot be used to interpret, my lord, a provision of the act. Otherwise, by changing the subordinate legislation, you can change the meaning of the act. That can't be. Subordinate legislation is made not by parliament, is made by the government, etc. How can the meaning of the act, or in this case, the constitution, change by looking at the rules? Therefore, namely, my lord, if the constitution says that both these streams are eligible for direct recruitment, then you can't exclude one. That has all been done on a misunderstanding of what the constitution says, and, my lord, justified by various courts, including some judgments of our court, including Dheeraj Moore, by thinking that 233(2) actually is a negative. This thing that that if you are a civil judge, then you are not eligible. That's what the article says.
Exclusively reserved for the bar judges.
Yes.
Yes.
Now, I was showing your lordship, my lord, the Shetty Commission report. And if your lordship straight away turns to page 656 of this volume 4, where does it start? Starts at 649. Yeah. The relevant portion starts at 656. And I'll just read some parts of it. Because, my lord, the Shetty Commission came to the conclusion that this kind of thing, that you are not eligible to sit for the direct recruitment, is creating a lot of frustration and a lot of stagnation among civil judges. And this is something that your lordship has recently noted, that the reason why we are getting not very good people for appointment as civil judges is because they feel that they get completely stagnated. I get into the service and then now for 15, 16 years, I will not even become a district judge. Your lordship has noticed, my lord, those.
We have issued a notice in that matter.
Yes, yes. No, so last week your lordship has issued notice, but before that your lordship noticed where your lordship has said that senior division should be the requirement of 5 years and senior division should be reduced to 3 years. Your lordship has noticed in that, my lord, in one part of the judgment, how long it takes to even become a district judge for civil judges. Sometimes in some states up to 15, 16 years.
Later when I was also telling the Honorable Chief, one of my law clerk back there in my High Court, I persuaded to accept the civil judge unit division. She's a topper. Last time she met me, then she said, I want to resign.
Yeah, correct.
Where do I end? These are aspirations of the young mind. So,
and
what extent we can curtail their.
Correct. And if your lordship were to hold.
Unfortunately, many of the brilliant candidates who join us with the senior divisions, they don't even reach up to the principal district judge.
Yeah.
Yes. They have to retire they get stagnated as district judges for years together.
Correct.
In our
And some of them are, I mean, one of these people who,
So we have to look at it not from their point of view also, from the point of view of the institution and the concept of basic structure.
Yeah.
The idea is to give a qualitative service from the judicial officers. If does not facilitate it, then you have to take, it will be a contrary to the constitutional mandate.
absolutely right. If you tell
You
people
have
that
to
if you are
make
accepting,
the bottom of pristine quality, and then you have to take it forward.
correct,
But if you make it much weaker, then it will justify the structure and keep going in appeal, revision, further appeal, SLPs. no?
absolutely right.
This is the
If your
problem.
lordship were to hold, my lord, that 233 to permit civil judges to sit directly for this direct recruitment of higher judicial service, it would encourage so many more people to take the civil judges exam, because then they won't feel like once we are in here, it'll take us 15, 16 years to become district judges. We are
They
excluded
will not
from.
come, sir.
Yes,
How do we encourage our juniors to take this examination?
correct.
So he is saying that if you answer that question in their favor,
Yeah.
then it.
That's right.
Come.
Absolutely right, my lord. Because if right now they have the feeling, ki, look, if I take this, I'm stuck. I can't sit for the higher judicial service exam. I can only go by promotion or limited departmental. And sometimes that you becoming eligible for that limited departmental comparative examination comes after, my lord, the date where you can be considered for promotion. And very often it takes about 14, 15 years. Whereas if this was permissible, then within 3 years they become civil judge, another 4 years where they'll have a combined experience of 7 years, at least they can sit for the exam.
So
They-
that you are agreeable, so even in the event.
But I am agreeable. I am agreeable, although, my lord, the constitution doesn't say so, but I feel that your lordship can lay down, because after all, there has to be a certain amount of experience that a person must possess for being. If you must have 7 years as a lawyer, you must also have 7 years as a civil judge, or combined experience of lawyer plus civil judge.
What about age? Because then, if for direct district judges, age is prescribed as 35, then if you are permitted to join it prior to that, it will not be discriminatory towards the members of the bar.
It
It's a gender restriction.
should be so long
That
as.
goes along with, see, now, even for the lawyers also, age
Yeah,
restriction is there.
That's what.
That gender restriction will be there. Age has to be.
It is another requirement. Age is another requirement.
Civil judges, I don't think there's an Article 14 issue. And, my lord, that is something that your lordship may, that is something that your lordship may consider, whether it should be lowered for both the categories, namely for lawyers also and for civil judges also, as to whether they would be more encouraged to take civil judgeship or even district, the higher judicial service exam, if it was less.
They put a state barrier with that. They cannot go outside the state. Only 5 minutes.
I was showing your lordship, my lord, the Shetty Commission recommendations. They realized that, look, this is a huge point of frustration for civil judges, and recommended that they should be permitted to take the higher judicial service exam, because till then, my lord, it had become a sort of a established norm that they were excluded. So Shetty Commission said this, but unfortunately, my lord, when the Shetty Commission came to court in that All India Judicial Services, that judgment, this part was neither noticed nor rejected nor accepted. So I'm just showing to your Lordship, my Lord, at page 656, conclusion, just below Article 233(2), about middle of the page, conclusion, 11.50.
6.5?
656 of volume 4.
Yes.
Volume 4 has all those historical documents, my Lord. We have given our anxious consideration to the views and comments expressed by the respondents to our questions 8.3 and 8.4. The majority of the high courts and the service associations, barring a couple of them, are for giving an opportunity to the service judges for direct recruitment of district judges. Even some of the governments are in favor of such a move. The reasons given in support of the proposal are that it would promote efficiency, improve discipline in judicial service, and make the officers to work more efficiently, diligently, and sincerely. We are highly impressed by the reasons given by the High Courts of Allahabad, Bombay, Punjab and Haryana and the All India Judges Association. If meritorious young blood should be introduced in the mixed cadre, there is no reason why merited serving judges should be excluded from consideration for direct recruitment. In such selection, the High Court will have an opportunity to assess their merit, the merit of serving judges as against the merits of the competent advocates. The Bombay High Court has rightly observed that the High Court in such selection will have an added advantage of assessing the service judges on the basis of their work and confidential records. So, the next page also, my lords, up to about 11.58 are the relevant parts of the Shetty Commission report. I know, my lord, I'm running out of time. That's why I'm just
No,
Rush.
you tell us what are the paragraphs which are relevant so that.
up to, my lord, from 11.50 up to 11.58.
We have eaten into your time in between.
No, no, Lord. That is part of my time, my
You have
lord.
to finish it in 3 days. no?
That is always part of the lawyer's time. Your lordship's questions are most welcome, my lord. That helps us to.
Unless your lordship,
Yeah, we have it.
it's not fruitful. I was saying, well,
Mostly what everybody would be doing is saying that we will not repeat anything but repeating the same argument.
we will try not to do it.
Or you have an
Lord.
experience, I have an experience of more than 6 years now. so.
Which of the interpretation of the hotel.
Lord, just one judgment I want your lordship to see. That is Hotel Balaji. Where is that? Hmm? Volume 7.
This 233A and B,
Yes,
1 and 2.
yes.
You mean to say in 2, if a person is having 7 years of service, then he's eligible.
No. According to him, he should have a combined experience of 7 years.
7 years service or combined experience as a lawyer and a service.
Although, my lord,
Or if he is a lawyer, then minimum 7 years as a lawyer.
So these 3 propositions.
yeah,
here.
correct. Although, my lord,
Please stop there. Because under 217 also,
yes,
10 years service,
yes,
10 years as a lawyer,
yes,
and suppose somebody is a judge for 9 years and he resigns. He's a lawyer, he's a lawyer for 1 year, then the 9 years experience has to be included.
correct. That explanation double A.
Yes, sir.
Absolutely right, my lord.
Double A.
Yes, explanation double A.
Even if he is a lawyer even for a day,
Yeah, so
and if completes 10 years, then he's eligible.
correct. Absolutely right. Of course, my lord, I'm not saying that this 7 years of either lawyer or lawyer
No,
plus judge.
my learned brother is
I know, my lord. I know.
saying that if a judicial
That-
officer,
that
because
should come-
we have had instances of persons reaching up to this code also, who are judicial officers and then also district judge and then high court judge. So he said that for being appointed as a high court judge, if you are in service for 9 years and then only a lawyer for 1 year, then your 9 years experience gets counted as a 10 years lawyer. So why not that analogy here?
Right. Now, my lord, I was just explaining that, and I'm grateful for your lordship's observation, but I'm just saying that requirement of 7 years as civil judge would not come from the constitution. If your lordship just comes back to 233, that would come from your lordship's, my lord, article 142 powers, namely as your lordship has done recently, that lay down that,
So it can be, by applying the principle of harmonious construction, also it can be said
although,
that if the constitution
Uh,
requires a 7 years experience as a lawyer,
correct.
then by same analogy, a person who is not having 7 years combined experience as
I
a lawyer
agree.
or
I agree, my lord, but that,
Yes.
that explanation
there's a lot
double A,
of debate on 142 now.
that explanation double A would be relevant only if the article had actually said that even as civil judge, you need to have 7 years. So therefore, there the hybrid, etc., would come into play. But my lord, 233 doesn't say anything about the experience as a civil judge. It only says
That we will have to read.
that your lordship can read into it. Yes, whether 142 or whether you read
Subject to hearing them, otherwise they will say that.
हाँ, now just कहाँ है वो होटल ताले?
So you see,
107.
इसमें मेरे केस लॉ में है ना?
हाँ.
Lord, just one judgment I want to read on the aspect of that you can't use subordinate legislation to interpret the.
is there any judgment necessary on that proposition?
No, quite, but your lordship must pronounce that judgment because, my lord, I'll tell your lordship why. I have been using this argument in several cases because it's an obvious proposition in my mind. Namely, how can you use the rule to interpret a provision of an act?
The rules and the statute.
Supposing there is no
Can't go away.
Supposing
There is a conflict between a constitutional provision and the statutory provision.
that's Kelson's pure theory of law, but that's a slightly different plot. Supposing there is no conflict, can you use a rule to say this is what the act means? And according to me, you can't for the simple reason that otherwise by amending the rule, can you say that, all right, now the act means something different? The act, what it means will have to be seen on its own. The rule can't change the meaning of the act. And I had been, my lord,
Yes, please tell us.
Volume 7, page 4240. Volume 5-7, no?
5.
Sorry, volume 5-7. Roman 5-7, page 4240. This is 1993, supplement 4 SCC 536. After having looked for it for several years, my lord, one of my juniors found it yesterday.
He deserves compliment.
What is the law laid down?
The law laid down is, my lord, if your lordship has para 17 and then 31 and 32. 4257 is para 17.
Hotel Balaji and others.
Yes. Because very often, my lord, in high courts, we find judges using rules to interpret provisions of the act. It's a reasonably common, my lord, mistake. That's why I'm saying that your lordship must at least lay down in this that no, you can't do that. So now, my lord, Placitum F on page 17.
4257.
4257.
Para 17.
That's the submission and then 2 paragraphs, my lord, of the finding.
At page?
4257, my lord, is the submission. And the finding is at page
4262.
4262.
Para 31.
Paras 31 and 32.
Read कर लो यार.
Yeah, I'll just read, my lord,
One way.
the finding. Go to 62
4262.
and 31.
31.
Yes.
If your lordship comes to page 4262, para 31, and I'll start at Placitum E.
Four two six two.
Yes,
Placitum E.
para 31.
The argument raises.
this argument raises in turn the question, how far is it permissible to refer to the rules made under an act while judging the legislative competence of a legislature to enact the particular provision? The necessity and significance of the delegated legislation is well accepted and needs no elaboration at our hands. Even so, it is well to remind ourselves that rules represent subordinate legislation. They cannot travel beyond the purview of the act. Where the act says that the rules on being made shall be deemed as if enacted in this act, the position may be different. It is not necessary to express any definite opinion in this aspect for the purpose of this case. But where the act does not say so, the rules do not become a part of the act. Sri Mehta relies upon the following statement of law in Halsbury's Laws of England, 3rd edition, at page 401. Consideration of subordinate legislation as aid to construction. Where a statute provides that subordinate legislation made under it is to have effective as if enacted in the statute, such legislation may be referred to for the purpose of construing a provision in the statute itself. Where a statute does not contain a provision and does not confer any power to modify the application of the statute by subordinate legislation, it is clear that subordinate legislation made under the statute cannot alter or vary the meaning of the statute itself, where it is unambiguous, and it is doubtful whether such legislation can be referred to for the purpose of construing an expression in the statute, even if the meaning of the expression is ambiguous. He says that this statement of law has been referred to with approval by Justice Hegde in his opinion in JK Steel Limited versus Union of India. Though in the opinion of Justice Hegde is a dissenting one, he submits the majority is not held to the contrary on this aspect. He also relies upon English decisions referred to in the opinion of Justice Hegde and points out that no decision of this court has expressed any opinion on the subject, a fact noted by Justice Hegde. He commends the view taken by Justice Hegde for our acceptance. Sri Mehta points out that further Section 86, which confers the rule-making power upon the government, does not say that the rules when made shall be treated as if enacted in the Act. Being a rule made by the government, he says, Rule 42E can be deleted, amended, modified at any time. In such situation, the legislative competence of a legislature to enact a particular provision in the Act cannot be made to depend upon the rule or rules, as the case may be, obtaining at a given point of time, he submits. We are inclined to agree with learned counsel. His submission appears to represent the correct principle in matters where the legislative competence of a legislature. So, of course, this was about legislative competence, but even when you are construing a provision.
You can't if you are construing a statutory provision.
Right.
It can't be construed on a. So this was with regard to whether the rules could be read as a statute.
Yes.
So for that, if there is a substantive provision in the statute that the rules will have to be read as a part of a statute, then it's a different matter.
Right.
If
Absolutely.
the statute does not provide for that, then the rules are always subordinate to the
Correct.
statute.
And any change in the rules can't change the meaning of the Act.
And statute would always be subordinate to the Constitution.
Correct.
So you can't read a statutory provision to interpret a constitutional provision.
Right. Absolutely right. And so, and here they are trying to read rules to interpret a constitutional provision. I mean, 2 steps high.
We have to
I'm very grateful to Lordship.
Thank you. In spite of our eating up on your time, you completed it.
But there was some, I would have distinguished their judgments, but not since for paucity of time, according to me, not they are totally contrary to those 2 judgments, totally contrary.
In any case, there are only 2 5 judges, Constitution bench judges.
That's right.
The other, if there are 2 or 3 judges judgments, they may not bind us.
Absolutely right. Absolutely right.
Dhiraj Mori is also 3.
Yes.
Yes, Mr. Datta.
My submissions are in a very narrow scope. If your Lordship sees my
You
written
are in
submission.
which number?
Yes, I'm in SLP 3076.
You can give the item number.
501.28.
0.28.
Yes, my lord, my submissions are very limited.
You can just tell us you are a
Yes, what, in simple
which
terms,
officer?
I was a lawyer. I practiced for 9 years. Then, my lord, I joined the judicial service.
Practice for 9 years.
I practiced, my lordship, just take my written submissions. The chart is there. It'll be easier, my lord. Take my written submissions. Starts at page 32.
Written submission. Mr. Bhushan started his argument with your submission.
Pardon me?
Mr. Bhushan started your argument with your submissions because your submissions only contain all the 4
Yes.
questions.
In fact, I'm going to request your lordship that I'm asking 2 more questions to be taken because the focus of my submissions is that para 45 of Dheeraj More requires reconsideration. That is the short submission I'm making. Because in para 45 of Dheeraj More, they've added 3 new conditions into Article 233(2), which I'm submitting requires reconsideration at your Lordship's hands. That's the
But
problem.
if we answer question number 4
Yes.
in the affirmative,
Not what my submission is, but still, even if your Lordship answers question number 4, the para 45 will still be a law under Article 141, because what the court has said, 7 years means 7 years continuous up to the cutoff date. So, Lord, there is a question as to whether what's the meaning of the word immediate past. So ultimately what Dheeraj More says is, suppose tomorrow I'm going to apply for the post of a district judge, I write the exam. Then on the cutoff date, that is the date of the application, I should be 7 years in continuous service on the date of my application. It goes on to say I should also be 7 years on my date of appointment. That's the problem.
on the rate of appointment also.
Also. So that is the problem.
So suppose if you appear for 2 examinations,
Yes.
the district judge and the civil judge,
Yes.
you get selected as a junior division. So
Yes.
that result comes first
Yes.
and you join that.
Yes.
And thereafter, when you are also selected for the district judge, the result comes 6 months thereafter.
According to that, I'll be disqualified. Because I must be 7 years on the date of appointment also.
Matters there. Kerala matters there on this surface.
Facts in Vijay Kumar Mishra.
Because-
What your lordships have recounted are the facts in Vijay Kumar Mishra, which was answered in favor of the petitioners by saying that you can resign and join, because they distincted between the process of selection and appointment.
Because the qualification will have to be as on the date of the application.
Exactly. That's my point. It did not go. And number one. And secondly,
Lordship rightly said, my lord, if question 4 is answered in our favor, that combined,
Yes.
then he also says through.
yes.
Well, then we were not, because that may open up Pandora's box. Suppose like Nandi Brother point was, suppose if you have a 7 years experience, then you give up your practice for 10 years and do something that you go to films or
No, for example, no, Lordship,
or
yes,
some
a sabbatical.
open a restaurant or something.
Yes.
And then after 10 years, you say that I'm coming back to the practice and now count that 7 years experience
Lord,
of 10 years back.
no, suppose I practice for 10 years and then I join, say, I become a lecturer in a college. And then I decide to write the exam. What is the bar? Number one. Number
But
two.
even then, I say, bar would come because you disconnect with the practice.
legal process.
Stage. You
No,
can't
no.
just go, maybe connected with the institution, connected with something.
That's the point, Lordship.
Technical officer, that's all that you
No,
can't.
what my
We
submission
can, we can understand if you.
You practice as a lawyer.
If you are a public prosecutor
Yeah.
or an additional public
That
prosecutor.
is Deepak Agarwal's case. Public prosecutors. No, what I'm submitting is one submission.
Or for that matter, a law officer. Law officer. So continuing with your legal profession.
No,
But
my
if,
submission, once I finish what I'm proposing for saying is this. Once on the facts of my case, my lord, what they say is, on the date of your appointment, you had not practiced for 7 years. I had practiced for 10 years, then I became a judge for 4 years. Again, I practiced for 5 years.
That's a different issue.
That's the problem.
That will cover what we
If
did.
we answer question number 4 in the affirmative,
Yes, yes.
then you will stand concluded.
But my other question is this. As my lords mentioned, ultimately the aim is to get the best possible pool for selection. Get the in terms of quantity, you'll get the quality also. If you get a larger pool of consideration, you may get a better quality. What I'm putting to your lordship is this. As far as my client's facts are concerned, if your lordship accepts me, it sails through, no problem. But 2 points are there. Whether Dheeraj More is right in saying that the 7 years should be continuous on the cutoff date on date of appointment. That's one.
It's very clear. I think the
It is the date of application.
Nobody
enough.
can say
That's
that
enough.
appointment.
So Lordship will just
Unless
para
it-
45.
unless it is so there.
Exactly. No, if your Lordship, then I will save time. The other larger question I'm saying is this, my Lord. Suppose, my Lord,
Let's
please see
put
para
para
45.
45.
Please see para 45 first. my Lord.
Yes.
Straight away at page 37 of my submissions.
Sir.
Neeraj Mohan. And the same thing is reiterated in the conclusion. So I'll just read para 45. In view of the aforesaid discussion, we are of the opinion. Para 45 reproduced at page 37 of my written submissions. Para 5.1.
Yes.
May I read, my lord? Lordship's got all lordships got it. In view of the aforesaid discussion, we are of the opinion that for direct recruitment as district judge, as against the quota fixed for the advocate/pleaders, incumbent has to be practicing advocate and must be in practice as on the cutoff date and at the time of appointment, and he must not be in judicial service or other services of the union or state. Full stop.
If we answer for this goes,
Yes, for constituting, correct. That goes. I'm only underlying the portion from my client's perspective, which is I'm just put. But since your lordship is in the constitution bench, we're getting a golden opportunity of completely interpreting 233 1 and 2, my lord. So that my humble request is let us consider all the ramifications so that this guidelines for the future also. Because after this, then if your lordship wants laid down the law, then it's completely settled. There is no other judgment of 233 except the old Raghuvar Dayal and Chandramohan. For constituting experience of 7 years practice as an advocate, experience obtained in judicial service cannot be equated combined, and advocate pleader should be in practice. Now, this is the problem. Should be in practice for the immediate past for 7 years and must be in practice while applying on the cutoff date fixed under the rules and should be in
we
practice.
answer for in the affirmative. This is
Correct. So that date of appointment will go.
Totally go to wash away.
On merit, we are with you, as my brother has pointed out, 217.
Yes.
That takes it. For a lawyer, services rendered as judicial officer can be counted even for constitutional court.
Yes.
And then the absence of any rule, any mandate under Article 233, it goes without saying.
So, my lord, if your lordship sees the box, the facts are given, I'm clearly coming
Vice
with.
versa will be a problem.
Yes, exactly. My lord, I'm also canvassing a larger problem because I'm just looking at this way, my lord. Today, my lord, the service conditions are very attractive for a district judge. The salaries are good. The service conditions are quite attractive than what it was when I was a junior. Now, my submission is this. The 233 says 7 years. Why 7 years? Because they want to fix a legislative period of maturity. For High Court, they say 10 years. For this thing, they say 7 years. So that doesn't mean at 7 years you can become. That's only eligibility. They say that till you are 7 years, you are not even considered to be eligible to be a district judge. And for Munsif, your lordship had put 3 years before. All those questions are there, whether they could go straight from the law college or they must serve 3 years.
Now you answered that.
Now you answered that question. So now there's a gradation. For the lower level, 3 years, district judge 7 years, High Court 10 years. This is the mantra. Now my only question is this. What happens to a case? Suppose I practice for 10 years. Now, suppose there's a break. Suppose I practice for 3 years. For various reasons, I may decide for financial reasons to take up a job. Because I know in my own case, when I was in Madras, there's a lawyer who practiced for 2 years in financial difficulty. He joined a company for 11 years, then resigned, and because he had saved money, and then practiced for the next 35 years as a successful criminal lawyer. Now, suppose he's practiced for 3 years, taken up a job for 9 years for financial reasons. Again, he comes and practices for 6 years.
Let us not
I'm saying don't 7 years continuous. Please consider it. I'll tell Lordship why. Because 7 years continuous not necessarily should be because the Constitution doesn't say so. It says practice for 7 years. What is the magic or what is the thing of 7 years continuous?
That will be, going
Difficult for us to
to
accept.
be difficult for us.
It has been rightly interpreted, that should be.
He has been in practice. Please see 233. I'll just.
Proceeding that 7 years, that's all.
But no, should it be continuous for 7 years? Should it be continuous? No, but I'll tell Lordship why. In Article 222, when transfer came in Sankal Chand Seth's case, the question was whether the transfer could be without the judge's consent. That was Mr. Sirwa's argument. Yeah.
We don't go by your factual scenario in your case. What the argument you are making is very difficult for us to accept. For example, say what if somebody is there not practicing for 6 years and 11 months, and 1 month is practicing. You wanted that earlier practicing period to be taken.
No, I'm not taking that. I'm not.
Continuous only.
No, the point is that will come in the question of suitability.
The disconnect, we must reconnect and be there for a reasonable time. And then if you say that, take into past function as a lawyer.
What I'm asking is question is, suppose I practice for 10 years. Suppose I practice for 10 years. I've completed 10 years. 10 years continuous practice I've completed. and then I join a particular service,
Yes,
say,
yes,
say law, and there I can always apply lordship is, because now the question is, should I be practicing advocate on the date of my application? My point is not necessary so.
On the date of application, you have to be.
Pardon me?
On the date of application, you have to be a practicing lawyer, either a practice, if you hold in
Or a
in
judge.
your favor, either a practicing lawyer or in service of a union or a state.
Has been a practicing lawyer, means you have to continuous this is just clear. See,
On the
otherwise-
date of application, you have to be.
No,
Maybe not on the date of appointment.
Yes, it's split. Split should
no,
not.
I'm not talking about split. I'm saying suppose I work for 10 years. Now, my lord, the point is that person as jurist, he can become a Supreme Court judge. I'm just asking myself the question. Please say Article 2.
Don't request a jurist with.
No. Unfortunately, my lord,
Unfortunately, somebody has been able to make it so far from that
no,
category.
I realized that 42nd Amendment dropped jurists in the High Court position. It was there for High Court and Supreme Court.
Earlier, High Court was also it was.
Not then.
So suppose, for example, if somebody practices for 3 years and then thereafter runs a bar for 10 years
Yeah.
and thereafter practices for 1 year,
No.
should that be taken into consideration as the entire experience at the bar?
No, I'll tell Lordship, my lord. My lord, it's a very good example, my lord. He's continuously in the bar. No, my lord, what I'm submitting is, take your lordship. No, lordship will kindly see. No, please see 233.
Too hazardous.
He'll have.
No. What I'm submitting is 2 questions, my lord. Suppose he has finished 7 years completely. He then takes
Yeah,
up
yeah,
job,
you right.
and then he resigns, and then on the date of
We
application.
don't want,
Then
we
it
don't want.
will be still covered by 4.
Yes.
That's enough.
If 4 is answering the affirmative, then it will be covered by 4. 3 years practice, 3 years in service, again 2 years at the bar.
Judicial service.
Judicial or public prosecutor or
That's it.
I'll put it this way, my
law
lord.
officer or something,
No,
something to do with law.
Yes.
No, I'll put it this way. Suppose a person is in practice for 10 years. He joins a tribunal. Because now today the whole difficulty in tribunal, you can't be more than 4 years. No.
It's almost a judicial.
No, Article 217 AA says judicial service is different, the tribunal service is different. It's not a judicial service. See, what I'm submitting is, if a person has finished.
Take a hard case and then lay down law.
No. Because what your lordship lays on principle should apply universally. And only a hard case will test the principle. In terms of physics, a proposition will be correct only if it tested on a hard case. That's why I'm saying. Lordship will just see 233 and I'll not go because my time is up just to. Because
12 more minutes. 12 more minutes.
I'll try to finish it before that. I'll tell Lordship why. Please consider 233, madam.
Yes. Yes.
233.2 I'm on.
Yes.
I'm saying whether we can add the adjective continuous. And that was added by Deepak Agarwal, by Justice Lodha, where he said, it's in the present perfect continuous tense. My submission is there is no present perfect continuous tense. I'm coming to that. Please kindly see para 233.2. A person not already in service of the union or the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. So if a person has finished 7 years appointment, now 2 questions are there. Whether 7 years should be unbroken, number 1, or it could be that he practices for 3-4 years. For various reasons, he has to leave the practice, he works, again he resigns, again he practices for 7 years or 10 years. What happens?
So you have not been a lawyer for 7 years.
If you are not connected with law for a
In the aggregate.
Has been, you see, past you can't bring it into present. That's a difficulty.
No. He has been a lawyer.
Honorable Chief said, on the date of the application, you should have put in continuous 7 years, and on that day you should be a lawyer. That's all.
either a lawyer or a member of the service.
Well, I'm grateful. Lordship is now cleared. Let's not go to date of appointment. Let's fix to date of appointment.
Date of publication.
Date of application.
Like the example we gave you.
I don't think they can
Suppose somebody,
put that also.
Yes.
if 2 applications are held, 2
Yeah.
selection are held simultaneously, the JMFC and 1 appears for both. The JMFC comes earlier, he joins.
Lordship will
And
just.
after 1 year.
Correct. Unjust.
That can't be to the detriment of a person.
And the person who applied, he can't indefinitely wait till the appointment.
till the-
Exactly. I'm only requesting my lord to say that 7 years, it need not be non-stop for a person.
That, we are saying combined. We are saying, if we answer in the positive,
Yes.
we say combined 7 years experience. So it
That's
could be initial 2 years as a lawyer,
Yes.
then 3 years as in service. You resign from the service, again you are immediately start practicing. then you have 2 years of
5 years,
practice.
3 plus 5, 8 years.
Plus 2.
Yes,
It makes out 7.
yes, enough. So Lordship will say that it's an aggregate, not continuous, because what, no, I'm requesting Lordship. No, because, no, kindly,
If there is a disconnect from the legal,
That
No.
would be very dangerous.
no, Lordship will kindly see, not judicial service. He could be a public prosecutor.
that is,
Number one.
public prosecutor, even for that matter, a law officer with, say, public.
Suppose working as a legal manager in the company, corporation. Suppose he works
He
in,
will not, he will not come. He is an employee that can't not come.
all right. Lordship will take, suppose a tribunal member, please come to 217 AA, 217(1). So now, Lord, just to clarify, since we're laying down the rules, it can be aggregate 3 plus 4 and a break can be towards the judicial service. I'm only submitting, suppose it's a tribunal service, kindly come to 217 AA.
Yes, please.
217, explanation. Now in computing the period, see, kindly come to 217, explanation AA. In computing the period during which a person has been an advocate of a high court, they shall be included any period during which the person has held judicial office or the office of a member of a tribunal or any post under union or state requiring special knowledge of law after he became an advocate. So now, Mala, today there are so many tribunals and the appointment is of 4 years.
Tribunals we may improve.
No problem.
Yeah.
See, it says member of the
Yeah,
tribunal.
tribunals or even a
No,
post
no, Malad,
requiring
just-
a knowledge of law.
I'm not
If
I'm not
he-
mentioning judicial service. I'm saying extended to tribunals also.
Article
no.
says member of the tribunal.
Because normally
217 AA, it's not said in 233.
it's a person.
Yeah, that's what I'm saying. So according to your lordship, Lord, suppose as a lawyer, for various reasons, I take up a job as a law officer in a company, as a legal man, that will not be qualified. In a public sector undertaking also, no. I take it that way.
Yes, but if he is in union, by giving an interpretation to AA,
Yes,
we can include a person
as a
who is
tribunal member.
in service under a union or a state requiring special knowledge of law, like under secretary, law department.
Or this are legal remembrance, like
Legal
V.S.
remembrance.
Deshpande.
We have had,
No, just V.S. Deshpande was also legal remembrance.
V.S. Deshpande and Justice Vazay.
Yes.
He was a law secretary in the Union of India, law secretary or additional law secretary. From there, he came to Bombay as the judge of the High Court.
Yeah, no. Yes,
So we can,
V.V. Vazay.
by giving meaning to expression AA,
Yes,
we can include this category of candidates.
yes. Sorry, madam.
But that will create complications. A
Pardon?
person is in JAG branch, Judge and Advocate General branch, whether he'll be included or not.
Yes, you will be included because you will be in the service of Union.
You know.
You will be in the service of Union. If,
Could be in the judicial, yeah, your lordship is right. I'm a JAG,
This can be
judicial
applied for a
JAG
constitutional
branch.
post. Whether when it can be applied for a constitutional post.
Why not? By logic, what do you
Yes, in the same logic, it can't be otherwise.
but not beyond this. Otherwise, then the combined experience of 2 bars.
Yes. So, no, lordship will just see what portion I wanted. So this portion of para 45, so that second point is correct. The earlier point, lordship will just take.
No, if we hold that the experience in any of the categories provided in AA
Yes,
would also be included,
yes,
then it will cover
that
everything.
will solve the problem. And lordship will kindly see, your lordship also to clarify that practice should be immediate pass for 7 may not be necessary. Continuous for 7 years may not be necessary. If there is a break break in judicial service.
Break on account of any of
Yes,
the services.
exactly. Because in Deepak Agarwal, para 102, they say, your service of 7 years should be unbroken before on the date of application, which may not be correct is my humble submission. Kindly come to Deepak Agarwal page para 102. And that's what is followed by Dheeraj More. Please come to Deepak Agarwal. One page.
No, we will say that, as Honorable Chief said, it will become unbroken. If you add with both these two, it will become unbroken only. Once, it will not break. Whether you work as a lawyer or a judicial service, it will not break.
Whether work as a lawyer
Continuous
plus
service.
217 AA categories.
That's correct. Only to that category.
Only to that.
That category, yes.
Yes. So lordship, to that extent, 102 of Deepak may have to be overruled. Kindly come to volume 5.2.
Yes.
Volume 5.2.
Page 86 of the current complaint.
Okay,
Which
fine.
I've just handed over.
Can I borrow?
Yes, sure. Page 86. You can take this. That's my part.
You're okay with that?
Yes, yes.
Deepak Agrawal.
Yes. At page, there was a question of whether public prosecutor, government leaders will also be included. Lordship will just come to Deepak Agrawal. Lordship will see the first page, at page 32 it starts. The question before the court
1 minute.
is set out at page 42. Lordship, look at page 42, Milord.
Yes.
So Lordship will know what is the controversy at page 42. May I read, Milord? Leave granted, that part.
One minute.
Page 42.
Page 42.
Yes. Page 42, may I read, Milord? Leave granted. What is the meaning of the expression, the service in Article 233(2) of the Constitution of India? What is meant by advocate or pleader under Article 233(2)? Whether a district attorney, additional district attorney, public prosecutor, assistant advocate general, who is a full-time employee of the government and governed by and regulated by statutory rules of the state and is appointed by direct recruitment to Public Service Commission, is eligible for appointment of district judge under Article 233(2) of the Constitution. These are the questions. And they answer it in the affirmative. But problem, para 102, my lord. May I read, my lord? 102 at page 86. As regards, may I read? All lordships have got it?
Yes.
As regards the construction of the expression, if he has been for not less than 7 years as an advocate in Article 233(2) of the Constitution, we think Mr. So-and-so was right in his submission that this expression means 7 years as an advocate immediately preceding the application and not any 7 years any time in the past. This is clear by the use of has been. The
So once
present
we hold that combined experience of
yes,
a lawyer and a judicial officer and any of those categories
yes.
mentioned in explanation double A.
So he need not be an advocate per se, because this paragraph says in Deepak Agarwal, advocate for continuous 7 years, which may not be correct. In your lordship's formula, advocate plus 217 AA plus I could 3 plus whatever it. That's so this paragraph may not be correct. This has been followed in para 45 of Dheeraj More. So lordship may, because even what the lordship said, present perfect continuous tense is not correct. It's present perfect tense. If you say present perfect continuous, there must be a verb.
Ending in ing.
Yeah, yeah, ing. I and ing. So we check Ren and Martin after a long time, my lord. I'm sorry to say, my lord, my children, there's no grammar in CBSE now.
They don't understand what is Ren and Martin.
No, there's no grammar in the syllabus now. Yes, not unknown, yes. So, my lord, my submission is my client's facts comes squarely to the point. She has finished 9 years, 4 years judicial service, and again 5 years. Therefore, selection should be. She was discontinued on the basis of para
But
45
we
of
won't be
the.
deciding the question, we won't be deciding the individual.
Yes. So, lordship, last 2 questions which I have raised, that lordship see if whether what lordship wants to deal with them in my written submissions. Just see the last page. I have done. Just.
State of application.
Para page 39 of my written submission. My humble request is para page 39, whether 7 years in Article 233(2) means 7 years continuous. Lordship may say it is 7 plus judicial, 3 plus judicial.
Yes.
And the cutoff date should be taken as date of application. Those questions Lordship may add and answer them also. Those 2 questions can be added.
Not necessary to add in our discussion, we'll.
No, I leave it to you. For clarity for future, it will be obliged. I've also finished on time.
Because it's not the taxation matter.
Can I have my compiler?
Sorry.
That compiler.
Yeah, sorry.
Sorry.
Yes, I will.
Will keep us awake.
I will actually finish within my time because my work is much lightened, because I am in the same category as Mr. Datar's client. But there is just one aspect I want to highlight, taking off from where he has left.
Yes.
you